Thank you everyone for joining us today. I'm Shahin Rothermel, and I'm joined today by Berge and Ari Rothman. We're partners in Venable's advertising group located in the DC and LA offices. We all defend companies in state and federal investigations and class action lawsuits and consult with clients on all aspects involving online advertising and marketing. Our contact information is here on the first page of the slides, and these slides will be made available to you after the webinar. Feel free to submit questions through the Q&A box, and we're also happy to follow up with anybody after the webinar. Today, we'll be talking about dark patterns. It's a hot term that's gained a lot of traction and visibility in recent years. At this stage, though, as you'll see, dark patterns is an amorphous term. It's not well defined. We haven't seen courts really apply the phrase to specific companies' practices. We're going to do our best to unpack it today and give some guidance on steps that businesses can take to reduce their risk. As you can see here on the agenda, we'll talk about how dark patterns are defined, what regulators are saying about them, what they're alleging, and some emerging state laws and regulations. We've got a lot of content today, so we will jump right in, and I'll hand it off to Ari.
So what are dark patterns? Dark patterns, it's essentially a subset of deceptive marketing. It's a fancy, sexy term that someone coined back in 2010, but has really gotten a lot of traction over the last 2 to 3 years. And it's essentially, the third bullet on this slide really captures it. They are marketing techniques designed to guide humans in an online interface, an online situation, to do things that they might not otherwise do had that design choice or advertising technique not been employed. And so we'll give you some specific examples. On the next slide, we sort of list them out. One of them, an example of a dark pattern, is a trick question, and that's when the question is designed to lead the reader to believe that the question says one thing and therefore the reader answers it in one way, when in reality a careful review of that trick question is that it says something completely different and gets the consumer to respond in a way that the consumer otherwise wouldn't have intended. Another so-called dark pattern is sneak into basket. By the way, especially when we get to Roach Motel, these are not our terms. These are terms that are sort of out there in the ether, so we didn't come up with these things. But this is what you'll see out in the space. Sneak into basket is when literally somebody puts something in your shopping cart that you didn't intend, or maybe you did it and didn't know you were doing it because of the way the marketing or the web page was designed. A Roach Motel will give you a specific example of that as well. That's where you get into a situation really quickly, like subscription, but then can't get out. So that's why it's coined that way. There's privacy, a dark pattern where you're tricked into publicly sharing information or even just giving it to the marketer that you didn't intend to give, or in a way or for a use that you didn't intend. A price comparison prevention, where the retailer makes it difficult for you to compare the price of one item to another, so you can't make an informed pricing decision. Misdirection, this is a big one. Misdirection, and there's a lot of testing on this, involves a situation where there are literally, could be a matter of pixels, graphics, other design techniques on a web page that draw the reader's attention to one part of the page while intentionally misdirecting the user from other parts. And those other parts can tend to be, for example, disclosures that are required by government agencies. And so misdirection is a big one. Hidden costs, that's where the costs are literally hidden from you, sometimes entirely, and other times not until the very end of a funnel, when, purchase funnel, and that would be after you have been led to believe that you've been informed of all the costs. And then the bait and switch, there are various varieties of that. That's when you set out to do one thing, or you think you're going to buy one product, or you think you're going to buy one product from one vendor, and then they switch it out to a completely different vendor and a completely different item that you purchased, and the purchase still goes through. Here's some more: confirm shaming, disguising ads, forced continuity, friend spam, and a false sense of urgency. Those are like the stopwatches. we'll give you all examples of these two so you can put some concrete examples around this, and so you know how it's being employed and how courts and regulators are treating these things.
Okay, so I'm up with just a couple of examples, and just a comment too. Some of these, like this example, it's something you can read on its face, and this is the trick questions example. You can see there's two check boxes here. The first one is sort of an opt out to opt in type of confusion, but the first one says, please do not send me details of products and offers from the company. And so usually we're used to opting in to get things, and this is actually asking you to opt out not to get this information. But then the second box after that is the reverse, and it says, please send me details of products and offers from third-party organizations recommended by this company. So you can see how it could be a little bit confusing if you're moving very quickly through these types of pages, which many of us do. That can sometimes trip you up. And again, this is an example that is out there, as all of these are. These are not from actual cases, but let's move to the next one. Sneak it in the basket. Again, a little bit more, you know, you really need to look here and watch for it. But here on the left, I think somebody has ordered, it looks like sneakers. It's pretty small, but there's something right below it that has been added. I think it's only an extra, you know, a little bit of money added to that, but it's in red. Maybe that would be the hook to say, well, hey, we put it in red, so you would have seen it and you can remove it. But the customer didn't actually remove this. It is in there because they would like you to buy it and they think it complements your original product. So that's an example there. And then the one on the right is an example of a from a domain name registration service. Here the example says we've added privacy, and they're telling you why. And actually they've added you to a $9.99 per year plan. You could even upgrade to a $15 per year plan. Or if you are paying close enough attention and realize you don't want this, I guess you would need to go and check the no thanks. So again, just some examples here that we have. The next one, price comparison prevention. So we're all familiar with sort of the helpful tool that you can do online. I use it a lot when I'm getting a new cell phone to sort of compare phones and features and prices, but you can take this a different way. And I guess in some cases, like maybe the examples here, make it a little bit more difficult for somebody to actually make that comparison. So if you look at the example on the left, it's, I guess we're comparing apples and oranges here, pun intended, I suppose, but you know, there's different measurements of what you're paying for these. Are you paying per unit? Are you paying per item or by group of item? I'm not sure how I would kind of discern this and understand what is the better deal there, but that's sort of a technique that they're illustrating there. And then another one again on the right side, again, just sort of giving you a lot of different options to look at it. It might be small on your screen, but when you get the slides, you can look into it further. But it is just lots of different options. They're not apples to apples. There's some confusing elements. There's maybe some different math involved to compare, but really probably the drive there is to get you to pick something that you think may be the better deal, but it is costing you more money. So, okay, keep going. I think Shahin, you may have the next example.
Yeah, so intentional misdirection. It's a design that's, it focuses consumers' attention on something to distract them from something else, maybe showing certain colors, certain text that people don't necessarily think about what they're doing and focus on what they're actually providing their payment information for, or personal information for. So this is an interesting example where people had to choose whether or not to buy travel insurance, but rather than something like a radio button saying yes or no, there was a drop-down menu saying select country of residence, and then no travel insurance required was between Latvia and Lithuania. So people had to actively click that to avoid being charged for travel insurance as opposed to just clicking on their country of residence. Hidden costs are costs that appear late in the checkout process. something like a surcharge or an upcharge that wasn't disclosed early on. One thing that I'll say here too that we should remember, again, these are all phrases that industry commentators and others have used. We're giving them to you here. But one thing that we do see as well is that sometimes you'll see combined quote unquote dark patterns, misdirection, as well as hidden costs. So be mindful that it might not fall into just one of these subsets. Again, it's an amorphous term. So the issue with hidden costs here is not that you're providing or that you're charging an additional cost. The issue here is that it is hidden. It's not disclosed. So it's not the fee itself, it's the disclosure of it. And I think that as we move forward, you'll see that is the issue with a lot of these. It's not that there's a certain practice that a company or business cannot or should not do. It's the messaging and the experience that the consumer has with that company and that website or that app as they're doing it. This is a great example. Privacy, we'll see this called different things, but we'll use the word privacy here. Privacy is where someone is put in a position where they are quote unquote tricked into sharing more information than they intended. A lot of times mobile apps will require consumers to share personal information in order to use the app, and then the data is shared in a way that somebody didn't expect or want. I mean, to the point about using multiple different so-called dark patterns, Ellen showed the example where you had to affirmatively click a box to opt out. That could also potentially be challenged as a privacy issue because somebody might not have intended to click that. They might have clicked the wrong box, not understanding that they were sharing their information. The other thing we're seeing a lot of are internet platforms that make it difficult for users to exercise choice over collection, use, and sale, the ability to opt out of certain uses, certain sales. Sometimes you'll see companies accessing a user's contacts as a way to identify and contact those individuals, or even selling or sharing those individuals' information. And then location data without a user's knowledge. That's a really big one we're seeing a lot of. Ari, I think this one's yours.
Yeah, so here we have the Roach Motel example, and this is essentially that the concept is that the website makes it hard for a consumer to cancel recurring charges, delete an account, unsubscribe from a mailing list, unsubscribe from anything for that matter, downgrade an account, change it in a way where it would be less favorable to the marketer. And an example of this is here on the screen, but this is very, very common, and the FTC has been all over this for years. You have an online system where from start to finish, everything is essentially online. You found the ad online, you enrolled online, you paid online, you got your materials online. I guess with stamps.com, it's not exactly completely online. I mean, you have to print out the materials, and back in the day, they used to send you things through the mail in the late 90s, early 2000s when it first came out. But the idea is that it makes it hard for you to cancel. In this situation, they're not letting the consumer cancel except by phone call during specified times. And the FTC, they haven't called it, at least I haven't seen the FTC call it a Roach Motel. They just call things like that straight up deceptive. It's the same idea where if you're selling a physical good or product and the thing is damaged, some retailers want people to take photographs of it on all 5 sides and send it back. It's just impossible to get a refund. It's impossible to get the charges to stop, or at least it's very difficult and cumbersome. So that's the idea behind the Roach Motel. The bait and switch, that is a term on the next slide that the FTC and class action lawyers have used. I just used it in a demand letter I sent today on something else, although I'm a defense lawyer. The bait and switch involves a situation where the user thinks they'll have one outcome, but because of the way the website is designed, or in this case, the call to action or pop-up is designed, they're guided to do something else. So this says if you do not update your system 5 days after this pop-up box, we will force you to update your system by disabling all your most used applications on this device. You can enable these applications again by just updating to our newer version. And so the idea is clicking on X resulted in the update occurring rather than clicking a different button to prevent the update from happening. And so that would be a bait and switch situation. Also, a bait and switch would be when, as I mentioned before, you switch out what the user, this is not on the slide, but what you switch out what the user purchased at the very end, you sneak, it's not sneak basket, it's complete replacement of what the user experienced. Confirm shaming. This is when the site tries to pressure you to sign up for something either at the outset or something in addition, and then includes language that makes, theoretically, I guess, makes the people feel bad by not doing it. So for example, in this case, you can get your free guide, or no thanks, I know everything about gardening. It's kind of, I don't know, offensive is the right word, but definitely a little cute. You had the same thing there on, we're giving you 30% off your full price. Get my 30% off. No thanks, prefer to pay full price. Which of course there's another option that says I don't want to pay anything, but they don't give you that option. They just give you those two. So that's what confirm shaming is about. If you have thick skin, this won't be a problem. The next slide there is disguised ads. This is when they sort of sneak an ad into a website to make it look like it's part of the website, but it really isn't. So in this example, you've got Softpedia, which is a site where you can download software, but here it looks like we have two ads from third parties that are not Softpedia. One is where it says start download there. There's two boxes around it, two pink boxes, and the other one is a download cleaner. And that's a dark pattern because you're inducing a consumer into believing that they are obtaining something from the site that they're on, when in reality, they're obtaining from someone else. By the way, this is also a bait and switch. I think it's a bait and switch. I think it could be both. Either way, it could be viewed as deceptive. Then you have forced continuity. Again, this is a phrase the FTC and the class action lawyers and the state AGs have been after for a very long time. And this is when you're asked to put in your information to get a free trial. It automatically converts into a subscription. Maybe you know about it, maybe you don't, but in a dark pattern or deceptive marketing situation, you don't know about it and you continue to be charged. And sometimes you don't realize it at all until you read your credit card statement. And of course, the marketers depend on you not reading your credit card statement, especially if the charges are small. And if it's hard for you to cancel, then we go back to the Roach Motel situation, and now you're in forced continuity and a Roach Motel. And that's a combination that we see a lot, on the defense side here. Next, we've got friend spam, and that it's kind of like I don't know if virus is the right word, but you put in email addresses to access online accounts, and then it sends out the bot or the system will send out emails. Sometimes it looks like it's coming from you. Other times it's just coming directly from the marketer. And that's just a way for the marketer to essentially get free mailing lists and free information from the user, me in this case, if I were filling this out without me necessarily knowing about it. There's no disclosure here saying that the emails are going to go out after I click on continue, but they in fact do. And so that would be considered friend spam. I don't know if this is me. I think this is you, Shahin.
Sure. I think it's you, Ari, but I'm happy to take it.
Oh, okay.
So what should companies do now that we've got, I can do the first one, Ari. This is an easy one. What should companies do? Don't panic. Everyone's throwing this word around now. Everyone doesn't really know what it means. We see the regulators talking about it. Nothing so far has changed. This is a rebranding of deception. The legal standard is the same. We have a lot of industry commenters that's been going. This is not a new term. These are age-old issues, but there are things that you should do. And Ari, perhaps you could talk about those.
Right. This really is nothing. Right. What she said. It's nothing new. The same rules still apply. It's just that the regulator is becoming more tech savvy, and so are the class action lawyers. You want to monitor complaint volume and type. If your volume of your complaints has to do with the quality of the goods or services you're providing, that's one thing. If you have a series of complaints in a defined time period that revolve around, I didn't know I was going to get charged this, or I didn't know that I was dealing with you, or I didn't know that I was going to get X instead of Y, as opposed to saying, the product didn't work, that could be an indication that there's deceptive marketing happening, and that would require investigation. You can also do the same thing with split testing. if you think you're going to make a change to your marketing, and you think that making that change might result in some sort of deception or so-called dark pattern, you can look at the results. I mean, if you're seeing a spike in sales, but also a spike in complaints, that's one thing. If you're seeing a spike in sales without a spike in complaints, then either, maybe you're really good at not being detected, but eventually in 60, 90, 120 days, when the chargebacks start coming through, if they're not reported immediately, that's when, you might see the problem. And by that point, it might be too late. So you really need to keep your eye on the complaints and start thinking about these things. Keep an eye on regulatory guidance and class action lawsuits and judicial decisions. One thing we're seeing a lot that I haven't seen before is a lot of, especially federal judges, well, actually, it's state and federal judges are being confirmed at much younger ages. A lot of them are now younger than me. I don't know if I'm getting older, it's just a change in the times, but they're a lot, and they're more tech savvy. And so you want to be, aware of that the audience has now changed, at least in the last 20 plus years since I've been doing this. And then, Ellen, do you want to do the last bullet? That's really your thing.
Oh, yeah. And actually, let me back up to the bullet right before that. It's only a matter of time until we see dark patterns actually, I think, alleged in an FTC or a CFPB lawsuit. But what they have each done recently is to they have a usual complaint filed under a sort of a deceptive and unfair practices type of theory, but the press release, which are frankly often scathing, and there's no sort of other side of the press release that it is what they want to say, will go into lots of dark patterns discussion. There's a case we'll talk about a little bit later, the CFPB case against TransUnion. And TransUnion made the point at some point, I think in a motion to dismiss, that even though the words dark patterns don't appear in the CFPB's complaint, it is no less than 15 times appearing in the CFPB's press release. So it just shows you how much they're onto this. The last bullet point on payment processors, really, this is another thing for processors to take a look at. As we've been saying, it doesn't necessarily change the game, but it does sort of add this heightened excitement and enthusiasm for deceptive practices. And whenever it involves taking money from consumers, this is where the payment processors have risk, because they've let that type of conduct into the system. So says the regulators and law enforcement agencies. So like everybody else, you'll need to pay attention to this as well and just track it and think of new ways to view these things. So we should move on in time. And I think this next part is for me too, just to talk a little bit more about the regulators' position on dark patterns. We won't spend a lot of time here because, as we've said already, they're really all over it. The FTC has started about a year ago, a little more than a year ago, with a workshop bringing dark patterns to light. They talked for a day about all of these same types of case studies and the psychological theories behind why these things happen the way they do, and lots of examples and why it's there, and all sorts of concepts like this is behavior that really benefits the designer of these patterns, not the consumer, not the user. They view these things very, very badly. They're intended really to hurt consumers. But pretty much any online practice, marketing practice now, whether it's on a website, a mobile app, even an email, and I think we had a question earlier about email. If it's deceptive, it's probably going to fall under the rubric of dark pattern right now, because that's just where the FTC is with this. So next slide. Just more on the panelists here, again, as we talked about, so we can keep going in the next slide. This is a statement. Actually, I'm not going to read all of this, but this is an interesting statement by then Commissioner Chopra, who's now the head of the CFPB. When he was at the FTC, he had this to say about the ABC Mouse case. That was the case filed under ROSCA, which is the federal law that governs online subscription enrollments. And in that case, the FTC had made allegations about not having clear and conspicuous disclosures about recurring billing and shipping and violations of ROSCA and things that we see in many cases. ABC Mouse settled, as many defendants do, settled without sort of admitting fault or guilt. But here, the press release, or Chopra's statement, I should say, on it, really kind of got into the dark patterns discussion again. And then there was the last bullet point is just where I'll call your attention is really just sort of something that was always on his mind at the FTC, and I know is on his mind again at the CFPB, is just to really go after the large firms, the large organizations that are employing these tactics, because he is tired of playing sort of this whack-a-mole strategy after these smaller players and wanting to go after the larger organizations. So we are starting to see some sort of bigger splash cases with names that you'll know, and that I think is certainly a risk factor for some of our larger brands. Let's keep going. The FTC is in the process of updating a couple of their guidance documents. The .com disclosures is one of them. There's specific questions they've asked to consumers and the industry about how they might need to update .com disclosures now that sort of things have changed. And we've now got all sorts of things going on with the metaverse and alternative currencies and all sorts of different ways to engage in electronic commerce, so to speak. It's kind of moved into a new realm. But dark patterns very much features prominently in this. There's this very specific question about it. And then there's some other things in there, for example, the third bullet down, how to determine the adequacy of online disclosures when you've got multiple pages or multiple steps to go through. The couple bullets down, how to handle space-constrained ads. You might recall that there's been some prior guidance about if you have a space-constrained ad, you can save your disclosure for the website, or even on a website, if you're on a mobile screen, maybe you can hyperlink to an important disclosure. So these types of concepts may be up in the air a little bit, and we'll have to see how long and what types of changes the FTC might come up with here. Next slide. Last fall, also the FTC issued a sort of a new policy statement on ROSC enforcement. Again, that's the online subscription sales, and together with it, issued a sort of a battle cry for more dark patterns enforcement. And a lot of that is really going to fall under ROSCA type cases. ROSCA, and I was starting to make this point earlier, but ROSCA, when you have something like making a clear and conspicuous disclosure of material terms being one of the sort of the components, there's lots of subjectivity of what is clear and conspicuous. And if a regulator thinks that it's not, they'll say it's not. So you could be fighting over some things like that, and dark patterns types of concepts can really complicate that. But anyway, this dark patterns enforcement trend is really closely tied to ROSCA, because ROSCA is one of the FTC's sort of mainstay law enforcement tools, now that they are a little bit weakened in the Section 13B area that we have covered in past webinars. So let's keep going forward. And this is just more, you'll all have these slides if you're attending this, and you can read them a little more closely. You can certainly look up these policy statements themselves, but this is just sort of the ROSCA enforcement policy statement that I've already referred to. So, okay, I think we can keep going. Let's go into enforcement. I think that is you, Shahin.
Yes, so let's talk a little bit about regulatory enforcement against things that they've called dark patterns. We're going to focus on some of the newer cases here. The first one that we'd like to talk about is DC versus Grubhub. This is a case that was brought by the Attorney General of the District of Columbia. It's an ongoing case, and this involves Grubhub's food delivery and pickup service online. And DC really took Grubhub to task on this. I think part of it had to do with the pandemic and with the fact that people were going online and ordering food delivery and other online delivery services. But the allegations are here that Grubhub allegedly inflated prices from restaurants and misrepresented to consumers that it didn't inflate the prices. It didn't disclose the full service fee until checkout. Its Grubhub Plus subscription program was advertised to provide free delivery without actually disclosing the service fees. There were phone numbers on the website that were portrayed as being direct phone lines to the restaurants themselves, when in fact the calls were answered by Grubhub, and therefore Grubhub took its standard fee for any products or services that were purchased through that phone call. And it bought domain names and microsites that appeared to be operated by the restaurants when they were actually operated by Grubhub. So I apologize in advance. These are black and white. We pulled these directly from the filings in the DC case. So you can see here that it says find restaurants near you, order online. What's the cost to use Grubhub? Grubhub is free to use. You'll pay for the food. You may notice that the restaurant charges a fee for delivery, and then that fee is set by the restaurant and would apply even if you placed your order by phone. So you can see here that Grubhub, according to the AG, was saying that its service was free, that the delivery fees were in fact imposed by the restaurants themselves. And just taking a step back, this lawsuit was brought under the DC Consumer Protection Statute. It's the mini FTC Act, and we've seen attorneys general enforce similar cases against online service providers, online retailers in the past. At this point, the FTC Act would not preempt cases coming from these types of state actions. I saw that we had a question on that. So the next item here is a bait and switch allegation that consumers were not presented with additional fees until the checkout page and the fees were not clearly explained. I think most people who've ordered services online have experienced this. Review and place delivery order. So somebody ordered a kosher style hot dog for $8.51, and at the end of it, they're paying nearly double to get that kosher style hot dog delivered to their house. I'll pause here and say that this is a DC AG action. It's brought by the government. However, we're seeing a similar case against Amazon that's pending on the West Coast in a private class action as well, that there were fees that are presented that only were appearing after somebody added something to their shopping cart and started checking out, so that they weren't clearly and conspicuously presented with these fees early in the experience. The next thing that the AG took issue with is Grubhub Plus. It's a subscription service, so people would pay either a monthly or annual fee to reduce service fees, reduce delivery fees. According to the AG, that when you join Grubhub, you can see this image here below, join Grubhub Plus and get free delivery starting today, that people in fact did not receive free deliveries. There was still a service fee that was imposed, and that service fee wasn't disclosed to people before they signed up for Grubhub Plus. So you can see here that the Grubhub Plus is advertising all of the different elements that it provides, and its average savings, the free delivery, cancel anytime, all these things. But according to the AG, they did not disclose that you would still be charged a service fee for those orders. The next case, which luckily the filing had color and not black and white, was New York versus FarePortal. This is a case brought by the New York Attorney General under New York's Consumer Protection Statute prohibiting unfair and deceptive practices. The Grubhub case is ongoing. This case resulted in assurance of voluntary compliance, which is a settlement decree between FarePortal and the New York AG. So that case alleged a few different things. It said that FarePortal would display a false message about the number of tickets that were left for certain prices, creating a false sense of urgency and a false sense of scarcity that was designed to prompt consumers to purchase their tickets quickly. They would add the number 1 to the tickets left. So they would say, if I'm looking for two tickets for me and Alan to fly somewhere, it would say only 3 tickets left at this price. And there was a countdown timer there that you can see here on the right. Here's another image of those tickets left, only 2 tickets left at this price. And that was something that the AG said imposed a false sense of scarcity and preyed on people's fear of missing out, was the language used there. They also challenged other quote unquote nudges. So for example, we also have seen the trip protection insurance. They said, and you can see this is a confirmed shaming potentially. Yes, I want travel protection. No, I'm willing to risk my $171 trip. And people were required to accept or decline this policy before they completed a purchase. I don't know which one was the default, but sometimes we see issues where somebody has defaulted into a choice that they might not actively want or actively choose. And that could allegedly be inertia, an issue with inertia. I mean, going back and taking 2 steps backwards here, this is all issues of how people interact with websites, what people are inclined to do, premised on things like people don't pay attention, as Ari and Ellen said earlier, people are lazy, that people have anxiety. There's discussions of how this preys on people who are anxious and they need to hurry up and book their ticket, and they have to hurry up because there's a countdown timer that's only giving them 5 minutes. They're not getting the chance to read all the disclosures or really understand that they're paying extra or not paying extra for something. Here's another one, a slash-through price. They said that this was a false savings. This is also not new. There are laws and regulations that regulate savings, claims, and sales pricing, but this was another issue that the New York AG took FarePortal to task for. Oh yes, here's another one, the 24 cancellation policy. So they told people that they could cancel within 24 hours of their booking, but they actually would not. You had to click this little info button. You can't see this, but it actually becomes an info button that provides some limitations on people who tried to cancel within 24 hours. They weren't able to. One thing that New York said here was that FarePortal got $5 million each year through people who tried to cancel within this 24-hour cancellation period, and they really took issue with that as well. So with that, Ellen, I'm going to hand it over to you to talk about the CFPB versus TransUnion case.
Okay, so this is a little bit, well, it's a recent case that it's more or less a contempt action off of a 2017 settlement that TransUnion agreed to enter into, really to resolve a CFPB inquiry there on marketing practices. I think the CFPB's issues that it alleged there were things like people signing up to see their credit score, and then getting themselves enrolled in an ongoing recurring monthly subscription for something like credit monitoring types of services and other types of credit related service products. So like many companies do, again, they settle to avoid the time, expense, and distraction of litigating with the government. Government investigations also, by the way, lag by many years. So whatever a 2017 settlement had in mind was probably for conduct that occurred many years before that. But nonetheless, the CFPB has come back basically today and said that since 2017, you haven't done what you were supposed to do under the order. You violated all of these other laws. Out in public, the CFPB says this is all a big matter of dark patterns, even though, again, the lawsuit, the complaint is really just about alleged violations of law. So next slide, please. So here, again, this is a little bit more of the allegations. This is folks going on to get a free copy of their credit report. They go through, they provide the information they need to get it. They are offered, in this example, a chance to see their credit score for free. But to do that, you had to sign up for a monthly recurring credit monitoring type of service. The CFPB didn't like how the disclosures were placed here. And so that was their issue here. Let's go to the next slide. And their 2017 settlement had a lot of language about requiring express informed consent. So we were, this was one of the one of the dark patterns that the FTC had flagged last fall, and the CFPB is looking at it here, is just making sure that somebody's actually, the user's actually agreeing. There's this concept of express informed consent. Informed meaning you have the information you need to make an explicit decision, an express decision about it. So according to the CFPB, this is not adequate for that. The CFPB was looking for a checkbox and some other signals here, maybe a darker presentation of the font, that, again, that subjective component, a larger, darker font. We're constantly talking about those types of issues, but we can go to the next slide. And the present day complaint in this case is actually really, really interesting. I mean, the CFPB does go through and make their allegations. You can see some of them here. Consumers who try to cancel can't do so. There was this is taken from the complaint, and this is how it is presented in the complaint. But this is a snippet of, I guess, a very small part of what a consumer would go through when they're online trying to cancel out of the subscription program. And you've got the really what this was doing was saying, hey, if you want to cancel, hit this continue it and cancel button so that you can cancel out. Or the CFPB said the back to my dashboard button was more greatly emphasized. But again, this is all we have, and this is all the complaint has. We don't have the full screen to know what else was around it. And TransUnion is actually fighting this case and has said that they're very much willing to litigate against the FTC here. So we'll have to watch that. And what is sort of a growing trend, I think, on some of these larger brands that are getting sued is to actually put out an affirmative press release to say, look, we're fighting this and here's why. So it's really interesting to see, and this one will be interesting to watch. Next slide. I think we can go to the class actions and private enforcement, Ari.
Yep, that would be me. So go through some examples of how courts have treated this in the private context. Of course, what we don't know are all the demand letters that people get, especially in California under the CLRA, but we do have some guidance on reported decisions. One of them is McQuaid versus New York Times. This came out of Oregon in 2022, and this related to the cancellation piece. I guess you could consider this Roach Motel situation that we talked about before. The situation involved enrolling someone into a subscription for the New York Times. That's nothing novel. That's been around since before the internet. But where the New York Times got sideways was on the cancellation piece. They had, they had told their consumers that they'd be able to cancel easily, and they could do so via chat. But then the chat facility had two problems with it. The first is it only had limited hours, and the second one apparently was that it wasn't available a lot of the time for the reasons provided was due to excessive chat from customers. And so that would be considered deceptive, I guess. It resulted in a settlement, and it was $3.9 million in access codes. I don't know what that translates into dollars for the New York Times, but they also had to pay $1.25 million in attorney's fees. So that is an example of something playing out recently this year. The next case, this is out of the Central District of California from a couple years ago against Live Nation. This was a putative class action challenging Ticketmaster's practices. The first practice that was challenged is on this screen here, where you provide your email address and password, and then they would enroll you or commit you to the terms of use and privacy policy of the site. Then on the next screen, where the checkout page is, if we could somehow get to that, this is above the fold. The total for this ticket example was $300. It's a little pixelated, but it says all sales final, no refunds or exchanges. By continuing past this page and clicking place order, you agree to our terms of use. Black font against white background above the call to action button where it says place order. This got challenged. What did the court do with it? In this instance, the court said that this was not unlawful. That in this instance, the marketer, the judge didn't say dark pattern as far as I know, but did not engage in any deceptive conduct. But you can see how the expert tried, from the plaintiff side, tried to get into it with the design flaws, such as lack of understanding for hyperlinks, lack of dedicated real estate page on the site is what that means, the lack of checkbox or other forcing feature, and the use of text with reduced opacity. But the court disagreed and found that the site was designed in such a way to provide consent or capture consent from users to the terms and conditions and the privacy policy. There's a case that came out recently, can't remember if it's on these slides or not, out of the Ninth Circuit called Berman versus Freedom Financial. That just happened in the last couple of months. And that case walks through why, in that instance, the company did not capture the consent of the user or agreement of the user, terms of conditions and class action waiver. And one of the key things that the court said there was, when you were in, if we go to the previous screen, it didn't have the language that says, by clicking on this button, you are agreeing to this. But the court said that could have easily have been added to the web page funnel. So you do have some guidance out there right now. And I'm advising my clients religiously to use that decision and this as an example of a way to comply, because a lot of the times what we see is the government action and the judge is just saying it's deceptive and agreeing that it is. But now we're starting to see some judges take a look at this more critically and find that it is not. Now, again, in Berman, the Ninth Circuit went against the marketer, but still provided great guidance that I've been using for my clients in there.
Hey, Ari, before
yeah.
you go on to the next case, we need to give the CLE code.
I don't know.
I know it, actually. It's
right.
patterns 2022. Patterns 2022. And that's my bad. I was supposed to do it a while ago. All right, keep going.
All right, so let's go on to the next case. We have Nichols versus Noom. This is alleging challenge Noom subscription program and the California automatic renewal law. Again, the automatic renewal law is pretty specific in California. And these are the dark patterns that were alleged. The hidden subscription dark pattern. The allegation was that it silently charged users for recurring fees under the pretense of a one-time or free trial. And we haven't used this term yet, but it was mental fatigue. They go under 58-step sign-up process with delay tactics, distractions, and just wear the user out so that by the time they get to the payment page, and even if the material or disclosures were made, the user is so tired that they're just sort of going to skim over them and just get the purchase done. Let's go on to and this was out of the Southern District of New York. Here's where it was. You have some issues here. I mean, the 14-day trial, you got the black lettering against a light background, and the charges and how much it's going to cost. You also have a timer at the bottom. Let's continue on. So those are the issues, some of the issues that were observed there. And here again, here's some more specifics around what happened in that decision. There's more trickery around the wording, the risk-free 100% guaranteed, even though it might not have been. Deceptive, the countdown timer, that's what we saw at the bottom of the last screen, and hard to cancel / the Roach Motel again. Let's see what the next slide is. So then Farmer
I can
versus...
take this one. I can take this one.
Okay. All right.
Sure. So this was a case that arose during the pandemic when Airbnb said that it would offer full refunds to guests who booked a stay on or before March 14th, 2020. But in many cases, the refunds that Airbnb had promised came directly out of hosts' pockets. So the question is whether or not Airbnb disclosed this cancellation policy both to its guests, both to the hosts, and whether or not it was treating those two sides of the transaction fairly. So the guests and hosts had previously had a cancellation policy that provided for a certain amount, a certain time period, and a certain fee that Airbnb was then overriding with this pandemic promise. But the problem was that Airbnb was using the host's funds essentially to compensate guests when they cancel it. So Airbnb said, okay, we'll set aside $250 million to pay hosts for the cost of canceled bookings. And they provided, the idea was that they could provide the hosts a certain percentage of what they would have made from the guest under the previous cancellation policy. In other words, to prevent the fallout of people not being able to travel, keeping the hosts somewhat happy despite those canceled bookings. But instead of issuing refunds, they issued travel credits, partial refunds, or even denying compensation in some cases. And the plaintiff in this case, Farmer, was a host. He was paid something by Airbnb, but then Airbnb actually charged back the money that it had paid to the host for that cancellation fee. The other problem, so not only was Airbnb, according to this case, stiffing the hosts, guests who tried to use the refund were required to provide a justification for why they couldn't travel due to COVID-19, even though that policy and that requirement wasn't disclosed on the front end. And here's a screenshot of what was disclosed to people on the front end. So it had the cancellation policy versus the travel credit policy. And the full cash refund policy is disclosed according to the website, the lawsuit in small font. One thing that was interesting here that Ari and Ellen talked about just a minute ago was that Airbnb moved to compel arbitration. So having an arbitration provision, a class action waiver, in many instances, if they're properly executed, can take a case from being adjudicated by a court as a class action in the front end to either an arbitration or only an individual claim if you've adequately got assent and you've disclosed those provisions, that dispute resolution provision. Having said that, those are provisions that would apply in a private lawsuit, so Airbnb was able to avail itself of that here, but it's not something that a regulator, we couldn't bind a regulator. The FTC or the CFPB is not bound to a class action arbitration or class action waiver and arbitration waiver. And in some cases, depending on how those are presented to consumers, depending on what is said in the terms and conditions containing that arbitration provision and class action waiver, it might actually be used against the company. A regulator might say, look, you're not even letting people avail themselves of court because you're doing this in a certain way and you're hiding this presentation. We've got a question on the Berman case that Ari just mentioned about the Ninth Circuit. That was a case where a company sought to compel arbitration. And Ari, keep me honest, was that a TCPA lawsuit or was that another case? I think it was a TCPA.
No, I don't think it was.
So the question there was whether or not the company had gotten people to agree to the terms and conditions that contained the arbitration provision and class action waiver. The presentation, so the defendant was sued. The defendant sought to compel arbitration and take the case out of court. And the court looked at the presentation of the terms and conditions and said, no, this was insufficient to bind consumers to the terms and conditions containing the arbitration provision class action waiver. Therefore, defendant was required to proceed in federal court as a class action. That was a Ninth Circuit decision that came out about a month or so ago. I'm responding to a question that somebody asked.
And yes, it was a TCPA case. It was a TCPA case. It was.
Yeah, so the idea here, and I think we're going to do a follow-up article because there was another case that just came out involving Dropbox on this issue about a couple weeks ago. So keep your eyes out for an article on this issue specifically, on what companies can do to reduce their risk of a private class action lawsuit or reduce the exposure at least of that happening when you've got terms and conditions. And we'll talk a little bit about those cases in a follow-up article so that you can have a more fulsome idea of those, because that's not exactly the topic we've got here today. Just a few more moments. We'll talk about state laws that now address dark patterns. Excuse me, the big one is the privacy law, the CCPA. The proposed regulations promulgated under the CCPA go into quite a bit of detail about what the regulators believe dark patterns are. They talk about what companies must do when people are seeking to exercise their right to choose the use of data, to opt out of sale. The first thing is that these disclosures need to be easy to understand, broken down for consumers who might not be that savvy and sophisticated. There needs to be symmetry in choice. We haven't talked too much about that, but we're seeing that a lot in both the privacy and the auto renewal context. The path that somebody undergoes to provide information or sign up for an automatic renewal cannot be less arduous than the path to unsubscribe. In other words, we can't reduce friction on the front end in order to get somebody to sign up and then make it completely arduous for somebody to cancel on the back end. That's what the regulators are saying here. We haven't necessarily seen that borne out in cases, but here's some examples of what the regulators are saying there. Another thing is also making sure that the request is clear, that you're using similar language. So you want to make sure that people have the option either yes or no versus yes and ask me later. Let people decide one or the other. Here's another, this bullet point where a choice where the yes button is more prominent than the no button, according to the regulations, would not be symmetrical. We see that a lot. A choice where the yes or opting in is much more prominent than the opting out or the choice not to participate. The next is avoiding language or interactive elements that are confusing to consumers. Double negatives. So let's say, do not share my personal information, which is required under the CCPA. Giving the choice of yes or no, that might be confusing because I have to say, well, yes, do not share, or no, do not share, which one is it? Toggle buttons that state on or off, again, might not be clear to consumers there. Unintuitive placement of buttons. This is an issue with opting out here, and also the Roach Motel model that Ari mentioned. We're seeing questions arise about where can I provide the cancellation button for people to opt out of my automatic renewal program or opt out of sharing of data. And it has to be intuitive. It has to be somewhere that consumers would expect it to be. Avoid manipulative language or choice architecture. So here are some examples, like a financial incentive. This goes back to the quote unquote confirm shaming we talked about earlier. Yes versus no, I like paying full price, or no, I don't want to save money. Requiring consumers to click through the reasons why they're submitting a request to opt out of a sale or sharing of data before being able to execute their choice. Again, we see this a lot in the privacy context. We see this a lot in the context of people seeking to stop recurring charges. This last button is a good one too. So making sure that people understand that when they're giving information for one purpose, that it'll be used for that purpose. So if I'm turning on location settings and letting an app follow my location settings, that it's used for that purpose, as opposed to using to sell to other companies and say where I'm going and what else I might be interested in. Easy to execute. This goes back to basic principles. Make sure that your links are working. If somebody's trying to opt out, if they're going through their account and trying to opt out of sharing or sale, or if they're trying to opt out of an auto renewal program, make sure those links are functional. Sometimes we see that doesn't happen due to complete inadvertence, not intentionally. Don't hide these buttons. Don't hide the ability for people to choose. It goes back to that idea that it should be unavoidable, and it should be an intuitive placement here. You can see here that the regulations would provide that any agreement that's obtained through quote-unquote dark patterns would not constitute consumer consent, and therefore, if you've obtained consent using dark patterns, then you're in the same position as if you hadn't had consent in the first instance. And then this last bullet point is really important, that dark patterns is a catch-all. An interface is a dark pattern if it has the effect of substantially subverting or impacting autonomy, decision-making, or choice, regardless of a business's intent. Again, it's going to be really interesting to see what happens with these proposed regulations, how they play out in court, because we really need to see the application to see if this is going to actually move the needle. There's a couple of other privacy laws that have similar language that define dark patterns and say that consent obtained through those dark patterns is invalid, or that, or where they would, this law under Oklahoma would say that it's unlawful to design a user interface with these dark patterns in mind. So that's all we've got for today. I know we had a couple questions that we'll respond to here after the webinar. You'll get these slides. Please feel free to reach out to any and all of us with any questions you have about dark patterns, and we will respond to those. And keep an eye out for an article here coming up about website terms, conditions, consumer agreements, and what you can do to further protect yourself in these cases. Thanks, everyone.